Welcome, everyone. My name is César Rodríguez-Garavito. I'm the co-director of the Center for Human Rights and Global Justice here at NYU School of Law, and the director of the Climate Litigation Accelerator, CLX. CLX is a collaborative project that seeks to accelerate and scale up the impact of climate action around the world. We do 4 kinds of activities. We conduct academic research and publications. We engage in online education and capacity building for practitioners in different regions of the world. We conduct legal advocacy and litigation with partner organizations also in different geographies. And we convene a global community of practice, which brings together researchers and practitioners from the global south and the global north to cross-fertilize their legal innovations, strategize together, forge advocacy collaborations, and forge partnerships that will hopefully see the light of day in terms of new cases and new campaigns and legal mobilizations. Today's event is precisely an illustration of the activities that the community of practice carries out. We organize monthly strategic webinars that last for 90 minutes, and we divide them up into 2 segments. The first segment, 45 minutes, is open to the public and discusses a case or an issue or a report, some sort of information that is of value to practitioners and scholars trying to anticipate developments in the field and trying to strategize together. Then the second segment is a closed-door strategic conversation among community of practice members based on the discussions that take place in the public segment of the event. If you're interested in continuing to engage with the community of practice, please do reach out to us. All the information is in CHRGJ's website. The case that we're focusing today really hits all the marks of the work that I've just described. It is a case of legal innovation. It has been done in collaboration. In fact, as our panelists will have a chance to discuss, it is currently at a stage in which several organizations from different parts of the world, including CLX, are preparing amicus briefs in support of the case before the European Court of Human Rights. And importantly, the case raises broader strategic questions. For example, the relationship between litigation at the domestic court level and litigation at the regional and global levels with institutions like before institutions like the European Court of Human Rights. We're fortunate to have 2 of the legal minds behind the case as panelists in this event. Gerry Liston from the Global Legal Action Network and Paul Clark from Garden Court Chambers. We'll launch into the panel right after a short video that captures a key element of the case, which is the representation of young people concerned about the impacts of climate change, of course, throughout the course of their lives. After the panel, which is going to last for about 30 minutes, we'll open it up to questions from the public, but as usual, all of us are used to this dynamic by now. For those of you in the public, please post your questions in the Q&A chat. I will make sure to bring them into the panel after we're done with the first round of discussion. So with that, let's go to the video about the case.
Hola, my name is Claudia, and I'm one of the 6 young adults and children who recently filed a climate change case against 33 countries with the European Court of Human Rights. We are taking this case because European governments are failing to do enough to tackle the climate crisis. And as a result, they are breaching our human right to live in a healthy environment where our physical and mental health is protected. In June 2017, during an extreme heat wave in Portugal, devastating forest fires broke out across the country. The forests were very dry because of the heat wave at the time, and as a result, the fires were able to spread at an extraordinary speed. Consequently, many people were unable to escape in time, and over 60 people lost their lives. Many of the deaths occurred close to where I live in the Leiria district of Portugal. Some people were killed in their cars when the fires engulfed the roads they were driving on. Fortunately, none of my family or friends were killed or injured. But what happened in June 2017 was a very troubling experience. I will never forget learning that so many people were killed so close to our homes, as the sky became filled with thick smoke and ash from the fires.
My name is Caterina, and I also took this case with Claudia. What scares me and Claudia the most is that we know the situation is going to get much worse if governments don't take the urgent action needed. In our lifetime, some parts of Portugal could see the number of days when there is an extreme risk of forest fires increase by 4 times, up to 90 days per year in some parts of the country. Heat waves, bringing temperatures of over 40 degrees, could last for 30 days or more, and extreme heat is deadly. If we remain on our current path, 30 times more people will die from extreme heat in Portugal in the final 3 decades of this century that happened in the first 3 decades. This causes us constant worry. How could we not be worried about extreme predictions like this? So, by failing to act on the climate crisis, governments are also harming our human right to our mental health. Our legal case is about us and how climate change affects our rights. But the fight against climate change to protect people is, of course, about all of us, both young and old. We hope that the judges in the European Court of Human Rights will do their part to address the climate emergency by demanding that European governments take the action that the science demands. Thank you.
Okay, against that background, Gerry, why don't we start by you walking us through the basic facts of the case?
Sure. Thanks, Cesar, and thanks so much for the opportunity to be able to present on the case today. So just to give you just a little bit of context about how the case came about, myself and Paul and a number of others in GLAN back in 2017 were just considering the question of how a climate change case could, at the regional level, could assist efforts at the domestic level. So this question was being bounced back and forwards within GLAN, and we were developing some ideas. And then in June of 2017, the fires that Claudia mentioned in her segment of the video broke out in Portugal. And one of my colleagues in GLAN, Rita Mata, happened to be from that same region in Leiria where these fires broke out. And it was through the connection with Rita that we came in touch with Claudia, Caterina, and the 4 other children and young adults involved in this case. And I guess in terms of the facts, the fires had just given them a horrendous wake-up call about the reality of climate change on their doorstep. And they're already, I mean, that's an extreme, a particularly extreme event, but they're already experiencing the interferences, the heat in particular, greater heat extremes that Portugal has been experiencing. The effects of that, for example, just on basic things like their ability to sleep and to exercise outdoors. But of course, it's the future impacts plus the longer term impacts in combination that this case is about. And I think it helps to think of it in terms of a wedge. They're at the thinner end of the wedge now. But Caterina mentioned some of the more, I think, the greater extremes that Portugal, which is particularly vulnerable in Europe to heat extremes, stands to endure in future. So as Caterina mentioned, for example, heat waves lasting over 30 days at a time with temperatures in excess of 40 degrees, kind of heat waves, the like of which the planet has, or at least that part of the world has never experienced to date, much as it is already experiencing greater heat extremes. So that's just a basic overview of the sort of factual context out of which this case emerged.
Thanks, Gerry. Let's move on to legal strategy. Paul, could you give us a sense of the basics of the theory of change and the legal arguments of the case?
Certainly. Thank you, César. So we start from what's no doubt obvious, if not from what Gerry said, from what you already know. And as the IPCC has said, what's needed is rapid, far-reaching and urgent change. Now, when we look at how litigation has gone so far, often in domestic courts, we see that many cases have met procedural issues, preliminary matters as bars, issues like standing or objection based on something like the political question. In many others, the substance of the court's consideration has been prevented effectively or determined by arguments about causation, saying any one state can't have attributed to it the harm that's an issue. And in perhaps the most famous domestic climate change case that's reached the domestic courts, the Agenda case in the Netherlands, which is rightly celebrated as both groundbreaking and incredibly important. Even in a case like that, when one looks at what actually comes out of it, because the court allowed or said that what was lawful was the lowest end of the equity range, of the permissible equity range, if that was reproduced by other states, the effect would be a temperature increase very far beyond the limits that the Paris Agreement aims for of 1.5 degrees. So when one looks at why this is the case, it may be all too obvious, but there are there's a constellation of factors that underpins this. One is the absence of any consensus at the international level on the right approach to equity or burden sharing. Could say a great deal more about that. There's also the fact that the language in Article 2 of the Paris Agreement, in terms of common but differentiated responsibilities, is heavily contested. And perhaps underlying all of this, those two factors and many others, are structural problems like the difficulty of causation, the difficulty of attribution, and the legal problems that come from that in terms of jurisdiction. These are problems which are effectively the result of a problem being caused by gas that doesn't respect borders. So our response to this is that what we need is an ability or a driving force in a case in which what's understood by the court is that the mitigation efforts of states need to be collectively consistent with the Paris Agreement, so 1.5 degrees. And in a couple of minutes, I'm going to try to outline what this looks like. So because each of the respondent states contribute to global emissions, we say they have to be presumed responsible for the harm or risk that climate change at its current trajectory poses to the applicants. And our evidence shows that currently they face the possibility of living to see 4 degrees of increase. The effects of that will flagrantly breach several of their rights as protected under the ECHR. So when the science shows that the world at large is on course for temperatures that will breach the applicant's rights, we say that the onus of showing how a given state's activities are lawful falls on those states. The problem of climate change doesn't go away just because a state blames another state through a self-serving and mutually contradictory account of equity, burden sharing, etc. We say that this puts states rightly in the position of having to extricate themselves from a position of presumed liability. So in practice, what this means in our case theory is that any ambiguity around the meaning of a state's fair share must be resolved in favour of the applicants. Now, this argument in legal terms is based in part on the general principle of law that where there exists causal uncertainty as a result of the existence of multiple potential contributors to a harm, then the victims, in simple terms, should get the benefit of the doubt. And principles like this appear across legal systems of the world. You'll no doubt be familiar with it yourselves. One famous example of it is the Summers and Tice case in California, but it isn't restricted to private law. It isn't restricted to criminal law. It's not restricted to adversarial systems, nor is it restricted to inquisitorial systems. And that is no doubt why it was recognized as a general principle of law for the purposes of Article 38 of the ICJ statute. Now, a closely related concept to this that we also rely upon heavily is the idea that where a number of persons engage in conduct that's attributable to several of them, to each of them separately, and that they contribute to the indivisible injury of another person, then the contributors share responsibility for that injury. Happily, I don't need to go into the nuts and bolts of this too much because of the fantastic work done by the SHARES project, published in the European Journal of International Law in their guiding principles on shared responsibility last year. Now, it's perhaps only because of the realpolitik of state power that there actually have been very few examples of this type of shared responsibility being applied to states. But there's no good legal reason for that. Now, we say that these principles, together along with a number of other structural concepts that we rely on, mean that in practice, states' mitigation efforts have to be assessed according to the more demanding measures of their fair share. And maybe that Gerry will say a little bit more about the use of the climate action tracker in this context in our application. So what I want to try and draw out from this is that rather than the bottom-up approach, are trying to first determine what a state's fair share is, and then assessing the lawfulness of each state's actions on this basis. The approach of the youth applicants in this case is to ask the court to first recognise that keeping global temperatures within the limits specified by the Paris Agreement is an absolute imperative, and then to work back from there to what that means for each state. And frankly, what that means is that if there's uncertainty as to whether a given state is doing enough, that means breach. Now, this avoids the pitfalls of the bottom-up approach that arises from intergovernmental negotiation like what led to the Paris Agreement. But we also want to be clear that our case theory is not straightforwardly a top-down approach either. In other words, we don't say that the European Court of Human Rights should determine what is the correct approach to equity and burden sharing for each state. We only say that the mitigation efforts of states have to be collectively consistent with Paris. And then to put it bluntly, it's the state's problem to demonstrate how they're part of an overall approach which is collectively consistent with Paris. So the case is underpinned with dialectics like that between top-down, bottom-up, but also between the domestic and the international. And then perhaps in 1 minute that I may have left, I just want to get onto the relationship between the domestic and the international, which is implicit in our case theory. Now, questions about how much a transnational court like the European Court of Human Rights should intervene on a given member state's decision-making in legal terms leads to the margin of appreciation in the European Court of Human Rights language. What is that? What that is really is a practical example of the principle of subsidiarity. In other words, the idea that in some circumstances, the fact that a state is closer, has better knowledge of its domestic affairs, equips it with a better and more appropriate basis on which to assess the necessary steps to comply with the convention. But the answer to that in the context of climate change is straightforward. There is no amount of local knowledge and no amount of proximity to the domestic level which could support an argument that the 1.5 degree doesn't need to be met. But again, we emphasize that this doesn't mean that our strategy is to try to disempower domestic institutions generally, or even courts. Nothing, and I really want to emphasize this, nothing in our position entails or suggests that domestic courts cannot deal with matters of climate change. To the contrary, in dealing with this application, the court, we suggest, has an opportunity to provide a basis on which domestic courts and institutions can act in the future in a way that provides a chance of collective consistency, a chance of holding the temperature increase to 1.5. I'm aware that I've gone over the time that I should have used there, so I'll stop there. Thank you.
Yeah. Thanks, Paul, but you already answered one of my questions, which is the relationship between the efforts taking place at the regional level, in your case, before the European Court of Human Rights, and the many interesting efforts, and some of them successful attempts at holding national governments accountable in Europe for their promises to the international community, or at least to do more in terms of meeting the recommendations coming from the IPCC and other scientific bodies in terms of climate action ambition. By the way, for those of you in the audience, this is the time to continue posting questions. We'll get to them in about 10 minutes. So moving to, or actually following up on one of the comments that Paul made about fair share. As many people know, one of the stumbling blocks, one of the main challenges to litigating climate cases, it has to do with how to determine what the fair share is for any given country, right? And states repeatedly raise the objection that, well, they're just a small country, say, like in the case of the climate litigation in Ireland, or even the Netherlands, right? In the landmark case of Urgenda, that was very much in the mix in the arguments posed by the government against the claims being made by the plaintiffs, that the Netherlands is relatively small, even although it's made historical contributions, its emissions are nowhere near China's or the US. So the issue is one of collective action, and until the world gets its act together, no single country would be legally responsible for doing more than what it's already promised to do. This case makes an interesting addition to potential responses to that argument, which is to use a well-known, well-established index, an assessment and a scientific assessment of climate action, which is the Climate Action Tracker. So Gerry, could you comment briefly on how you have used the Climate Action Tracker, and by the way, what you're asking the court to grant by way of remedies to the applicants?
Sure, thanks, César. So just picking up on what you just mentioned in your question, César, but also what Paul mentioned about how we seek to resolve the ambiguity around the whole issue of equity and fairness, and that this ought to be resolved in favor of the youth applicants in this case, and indeed all victims of harm and risk of harm from climate change. And this, in practical terms, is something which dovetails very nicely with the methodology of the Climate Action Tracker. And what it does is, because there is this uncertainty around fairness, there are many, many different ways of measuring a state's fair share. And the Climate Action Tracker doesn't choose any one of them. It doesn't make the philosophical judgment call as to whether, for example, historical responsibility is more appropriate than economic capacity, for example. Instead, it just takes all of the ranges, all of the different types of measures, and creates a range. And essentially, it just recognizes the reality that if every state's mitigation efforts are more in line with the less onerous end of its fair share, of a state's fair share range, we overshoot the collective target. Conversely, states' mitigation efforts must be in line with the more onerous ends of their fair share range in order to meet the collective target of the Paris Agreement. And that picks up on what Paul mentioned about our case being fundamentally about the need for states' mitigation efforts to be collectively consistent with the 1.5 degree target. So that's why we referred to it as something which is one approach, at least, that is consistent with the overall fundamental legal argument that we advance, again, emphasizing that need for collective consistency. In terms of remedies, so as you'll know, the kind of most common remedy, aside from just satisfaction or financial compensation before the court, is just a simple declaration of breach, and that's the type of remedy that we're ultimately seeking in this case, or that the youth applicants at least are seeking from the court. But it's the basis, the the path the court takes to arriving at that remedy, or that we hope the court takes in arriving at that remedy, which we think will be most important from the perspective of domestic litigation, and how this judgment could filter down into the domestic level. Again, the idea that it's the more onerous end of states' fair share, or for example, other types of approaches to mitigation that are consistent, collectively consistent with 1.5 degrees, that principle has to be at the heart of any proper approach to the application of human rights law to this issue. So in the agenda context, that would involve, rather than the court opting for the 25 instead of the 40% end of the range that was presented to that court, at least moving more towards the 40% end of the range.
Thanks, Gerry. This is where we move to rapid fire Q&A, because we have very good questions and very limited time. So I'll ask the final question that I had on my list and immediately move to the audience's question. One interesting feature of this case is that it involves extraterritorial obligations, but within a confined space. So it's somewhere in between holding governments accountable for their harm to the world, to the planet, and holding them accountable only for the harms that the harms that governments cause at the domestic level. And one interesting feature of the submission in the case is that it is asking the court to consider emissions released outside the country's borders. So there's 33 states that are the respondents in the case, and by the way, they're busy writing the responses because they're due by the end of this month. And it is argued in the case, in the submission of the applicants, that states must take responsibility for emissions relating to fossil fuels, which they export, the production of goods which they import from abroad, and the overseas activities of multinationals headquartered within their jurisdictions. It's a highly complex legal issue, but I'm going to ask one of you to give us the beginning of an answer in 2 minutes. How do you go about legally supporting this this claim about extraterritorial impacts of states' emissions regarding climate action?
Sure. Well, very simply, there's a very helpful line in one of the Strasbourg Court's most well-known decisions in the environmental context, Budieva versus Russia, which simply states that in the environmental context, particularly when harms to the right to life are an issue, that states must do everything within their power to prevent that harm. And even though I suppose the accounting framework that's been adopted under the UN FCCC has always been a territorial approach, it's clear that states do contribute to global emissions and ultimately climate change through how they interact with other countries. And obviously that was the issue in the Norwegian Supreme Court decision, which unfortunately did not go the way we would have hoped. And then I think that it similarly sort of ties in with the fundamental idea of shared responsibility, which is that states can't pass the buck to other states. It's shared responsibility is fundamentally about preventing states from buck passing, and that's something that states do in terms of exploiting the loopholes in the current framework through outsourcing emissions, for example, by offshoring production essentially, and shifting the emissions, say in the case of the UK, predominantly to China, where a huge amount, UK being a predominantly services-based economy, imports its goods from China predominantly, and those goods, the production of those goods makes a huge contribution, obviously, to China's emissions. So it's about countering that conscious effort in many ways that some states have made to reduce their own emissions by just shifting them elsewhere.
Thanks, Gerry. Again, a 2-minute Q&A cycle here. I think this is mostly for Paul. There are questions about the exhaustion of domestic remedies that have to do with what you explained, Paul, in terms of the relationship between domestic and international litigation. So one of the participants is asking whether you could address more explicitly your argument regarding exhaustion. Why do you think the European Court would be amenable to providing guidance to national courts on addressing the adequacy of the state's climate action if those individual states' national courts have not had an opportunity to address the question? Wouldn't that be an advisory opinion?
Thank you very much. In short, I understand the thinking that leads to the advisory opinion question, but this is not simply a question of principle for the court to ask. If the court were asked to determine a question of principle, it would effectively be, is there such a thing as shared responsibility? And the answer to that would be straightforwardly yes. Instead, what we have is a very specific group of applicants who are affected by the specific circumstances, the factual scenario that they find themselves in. Now, we don't say that every type of situation like that should go straight to the ECHR, but we do say that it's necessary for the court to deal with facts like the applicant's in our case in order for the timely application of proper decisions at the domestic level to have any chance of being genuinely collectively consistent through a view of shared responsibility at international law of the type that I've described. So there's a constellation of factors which have to be borne in mind simultaneously, some of which are concerned with the urgency of the situation, some of which are concerned with the specific questions that the court needs to respond to, and some of them are concerned with the impracticality of asking these applicants to bring their case through every one of all of the respondent states that they attempt that they would need to do in order to get the remedy that this case specifically seeks. And the last point is because as children and young people, there's a level of vulnerability and also a stringent limitation on resources. And we say that taken together, all of those things mean that either there isn't a domestic remedy that should be exhausted, or that the court should excuse the applicants from what might be understood to be the requirement to exhaust in every single state.
Thanks, Paul. That's a good segue into the next question, which has to do with the fact that the case is about an application of children and young plaintiffs, and CLX has been tracking down all the cases based on human rights arguments that have to do with climate change around the world. And in fact, one of our researchers, Elizabeth Donger, is writing about those cases. And we found that there's a total of 25 cases of this type in her estimate. And so there's this growing trend, and certainly the fact that you are litigating this case, and it's quite visible in Europe, has provided an additional momentum to this type of litigation strategy. But the question is, how is it significant for your legal arguments that the plaintiffs are children rather than adults? Do you see any risks involved in involving young people in litigation of this kind for either of you?
I'll start. I think perhaps Gerry, I'll pass on to you because you've met the applicants many times and know them in person very, very well. But I will say this about the legal strategy. The case includes a fairly novel point on discrimination arising from age, that effectively that because of the kicking the can down the road approach that many states have taken, the impact is to cause a discriminatory effect on young people. I'll pass over to Gerry.
Yeah, and I think just picking up on that, I mean, I suppose the fact that the worst impacts of climate change, much and all as they are materializing in Portugal already, and that these children and young adults are experiencing impacts already, it's in the later stages of their life that the real sort of catastrophic, enduring catastrophic impacts will be felt. In terms of the risks of involving children, certainly something we've been hugely conscious of, just even at a very practical level. You know, this was a group of children and young adults who didn't have any sort of public profile or experience in engaging with the media. And obviously, even if you have just 1% or 5% of comments on the bottom of a Facebook thread or whatever it may be that are hostile, that can be very troubling for anyone, but certainly for children and young adults. So I guess it's just been a process of working with them and making sure they feel secure, because, you know, as the case has progressed, they've ended up in the public spotlight more and more, and just constant communication just to make sure they feel secure, and that you know, that they're comfortable, and they've grown really into the role of engaging with the media as media attention has increased around this case.
Thank you, Gerry. Let's close this public segment of today's event. By the way, for those of you who are members of the Committee of Practice, you will have received a separate link for the Zoom meeting on strategy, which will meet right after this event is over, this public session is over. So last question has to do with margin of appreciation. This is a word that gets thrown around by courts, especially in continental Europe and in Latin America by courts. But of course, the margin of appreciation that is given to a government in terms of determining their level of ambition regarding climate change and carbon emission reduction varies. So it's a fluid category. Some courts have understood it more narrowly and have said, well, precisely because this is a new existential threat, governments have a narrower margin of appreciation in terms of how much they can do and what they can do to combat climate change. Whereas other courts have been much more deferential to governments, have said, well, historically, environmental issues have been left to the government to decide on. Environmental issues have been treated more like economic policy issues as opposed to kind of fundamental human rights issues. And yet in this case, you're making a strong argument based on some precedents of the European jurisprudence that climate change calls for governments to, for courts to hold governments accountable in a much more demanding way, and giving them a narrower margin of appreciation than they would have gotten in similar, in other less monumental environmental challenges. Could you comment on the use of margin of appreciation? Would you expect the court to say it on this front for either of you?
I'm happy to start that, Gerry, perhaps. I think it's important to be clear about a couple of things. One is that the specifics of which institutions are involved, the relationship between a domestic government and the judiciary within that state is a very different thing, obviously, from the relationship between a transnational and international court and the governments over which it has some jurisdiction. This is reflected in the court's case law, which makes clear, perhaps in ANUK, for example, that the margin of appreciation is a different thing from the deference and the arguments around the separation of powers that arise in domestic litigation. The other thing that I'd want to emphasize is the need, I think, when thinking about how the margin plays out, to keep in mind what distributive principles actually underpin it. I've already made reference to the subsidiarity idea as what drives it. So the question is, what is the reason why it's more appropriate for a particular entity in, say, a domestic state compared to a transnational court to consider a particular issue? And here we distinguish heavily between the need for consistency with the overall goal and how you divide that up. And so we say that there's absolutely no basis in any kind of idea of subsidiarity or any idea of deference to any kind of executive or governmental entity. There's no way that principled idea could ever lead to the argument that the 1.5 degrees is movable. Instead, what the states can refer to in respect of their subsidiarity position is that their means of realizing that need may well be something that they can and should figure out for themselves. What our case does is puts the problem of solving that in their court, because it's a problem created by the collective emissions of states. So the collective consistency of those states with the emissions targets is how to locate the place where that should be solved. So it's a transnational court, or any court, but particularly transnational court, which is well placed to make the argument that the position overall is collectively inconsistent. Then the ball is in the state's court.
Gerry, any final words on this?
Yeah, well, I just think it's interesting looking at some of the courts' case law in the environmental context when the margin of appreciation, how it applies the margin of appreciation, and it's typically to determine in the Article 8 context, the right to privacy and family life, the extent of the interference with that right that is permissible. So obviously picking up on what Paul said, no interference that involves global warming above the Paris Agreement target is a permissible interference, can be deemed as necessary in a democratic society in the language of the convention. Therefore, the question that the margin of appreciation has been used to answer in prior decisions in the environmental context is in fact already answered by the Paris Agreement and by the consensus, the scientific consensus around the 1.5 degree target.
Thanks, Gerry. Thanks, Paul, for a really engaging session. For those of you in the community of practice, this is to be immediately continued in the strategy session. And for those of you who attended our webinars for the first time, the public section of segment of our event, if you're interested in being part of the community of practice, please reach out to us and we'll get back to you. Thanks, everyone, and have a good day, afternoon, evening, depending on exactly where you are calling in from. Bye-bye.